Further hearing in the Queen against Jogee and Ruddock against the Queen.
Yes, Mr. Stevens.
My Lord, before I continue, in fact, Mr McGuinness is just going to mention one thing briefly, if that's all right.
Yes, of course.
Lords, my lady, there's a copy of the law report of Siddiqui, which was mentioned yesterday when we were discussing
Yes,
these sections in the serious crime.
absolutely. Thank you very much.
Oh, it's not movable.
So, my Lords, yesterday I made my submissions regarding the rationale and basis for parasitic accessory liability. I also made submissions in relation to the subjective nature of the test. And, of course, I made great play of the fact that it's not merely foresight, involves participation and all of that. May I, picking up from there, go on to mention one further point in this context, and that is this, that obviously, as was ventilated yesterday, D2 must already be engaged in a criminal enterprise, crime A, and there is, for that reason, a nexus between the two crimes. But, my Lords, it often goes further than that. So D1's participation in crime A, D2's participation in crime A will often provide a conducive environment and encouragement for the commission of the greater offence. And in some cases, withdrawal by D2 from crime A would undoubtedly make crime B altogether less likely. But, my Lords, similarly, though in reverse, there is an important point which was made by the Law Commission in its 2007 report, namely that crime B will frequently be logically referable to the success of crime A. So crime B may be committed to facilitate crime A, or so as to enable the participants to escape. My Lords, the reference, I certainly won't take you to it, in the 2007 report is paragraph 3.139. Now, my Lord, that consideration, together with all the others I addressed you on yesterday, in combination...
Sorry, the reference again, Law Commission.
I'm so sorry, my Lord. 3.139.
Thank you.
That point, together with the other considerations on which I addressed you yesterday, in combination, make in our submission for a coherent and principled basis of liability. My Lords, in that context, it is also relevant to note that the test with which we are concerned, or a variant of it, applies in other jurisdictions, including, though in different forms, through the legislative codes in some common law jurisdictions. Now, my Lords, we haven't even attempted to carry out any exhaustive research, but just by way of illustration, so far as the Caribbean is concerned, apart from Jamaica, Antigua and Barbuda, St. Kitts and Nevis, and Grenada all follow Chang Wing Siu. I think I mentioned yesterday, but in case I didn't, I ought to mention that in Trinidad and Tobago, the position is modified somewhat because of the reintroduction of the felony murder rule.
Yes.
My Lords, I will, I know, be corrected by Miss Geary if I'm wrong, but my understanding of the position in Australia is that there are 3 states, South Australia, Victoria and New South Wales, who all follow the common law per Chang Wing Siu, as I say.
Which haven't got codes.
Which don't have codes,
Yeah.
and for that reason do so. But I know Ms. Geary will correct me if there's any nuance involved in that, but I think I'm right about that. My Lord, there are just a couple of other points to make in terms of comparisons. We dealt with the position in New Zealand, which has a code, in our foundations note at paragraphs 109 to 110, pages 340 to 341. I won't take you to it, but I'll ask you just to bear it in mind, only for one reason, and that is that in the case of Ashin, Dame Sian Elias, the Chief Justice, construed the word probable consequence, or words I should say, probable consequence, as used in section 66(2) of the Crimes Act 1961 as meaning something that might well happen. The only other point I would make in relation to comparative material, and I stress we haven't attempted to carry out an exhaustive search, is that in a number of other jurisdictions in which there is a probable consequences test, that is determined objectively, not subjectively. And my lords, merely to make the point without taking you to the authority, in Darkan, which is at volume 5, tab 90, page 2302, at paragraph 125, the point was made that under the Griffith Code, where an objective, as I've just said, as opposed to subjective test is used, the trade-off for that more stringent standard is the adoption of a probable, not possible, test of foresight. My lords, I only make these points so your lordships are aware generally of the position elsewhere. I hope that that's a sufficient illustration for present purposes.
As far as New Zealand is concerned, and Dame Shauna Elias's judgment, I mean, that was, she was construing a statute.
She was. My lords, I only...
No, so the word probable had been used by the legislature,
yes,
and the court had to determine what it meant.
Yes, indeed. And the only reason for mentioning that, my lord, is I'll be saying in a moment that there's a great deal of difficulty in using the word probable,
yes,
it being one of the suggestions before your lordship, although a long way down the scale of the suggestions, that would be an alternative test. Now, my lords, I rely on the material I've just referred your lordships to very loosely as supportive of my proposition that this is a coherent and principled test, because it would be surprising, at least, if this test was regarded or was illogical, incoherent, or unjust for it to have been adopted or to be applied in the way it is in so many different places, albeit, I accept, in varying forms. Now, my lords, can I then just make a very brief point about policy arguments justifying PAL? I don't suggest for one moment that they alone justify it, and I acknowledge, of course, the competing policy arguments. But the fact does remain that, as the Law Commission has recognised, and as has been said by a number of judges, criminal ventures do have the tendency they have to escalate. And imposing liability based on foresight may have a legitimate deterrent effect, both generally and more specifically in the context of multi-handed crime and, in particular, gang crime. I don't seek to push that submission any further than I just have, but I endorse, if I may, with great respect, the observations on that point made by Lords Hutton and Steyn, respectively, in Powell, by Sir Robin Cook in Chang Wing Siu, and, of course, the submissions made by my learned friend, Mr. McGuinness. I don't suggest policy is the answer.
There is one point of interest about all that. The escalation risk, which is obviously familiar to those who try these cases, was very much in the mind of the Court of Appeal in Reed. Yes. Lord Justice Lawton's judgment, with which Lord Justice Lane was a concurring member of the court, emphasises that in indicating why it is that in the sort of venture one's talking about, an accomplice who lacked the mens rea for murder was guilty of manslaughter. Now, the House of Lords and Privy Council, in the case you've mentioned, address the escalation risk, but nowhere do they address Reed? In Chan Wang Su, Reed wasn't cited by counsel. In Powell, it was cited by counsel, but notwithstanding the Court of Appeal had addressed this very point in a reserved judgment, it simply passed over in the judgment. And therefore, the question which poses itself, why is the escalation risk insufficiently dealt with in the May that the Court of Appeal thought was right in Reed, and requires an increase to murder, is simply not addressed. And one is left asking, because the language almost implies that the alternative is that the defendant go free. Whereas really one's looking at the homicide structure as it's been developed at common law, and asking whether this particular category of case should, either consistent with principle or because of pressing social need, be reclassified murder, not manslaughter. And I would be, it's because that point really wasn't addressed in those cases that one is left looking at it without the benefit of their thinking on the point.
Well, my Lord, I obviously accept what your Lordship says about it not being addressed. But of course, my point of departure and fundamental submission is that there is a principled and coherent reason for the test, on which I addressed you yesterday and briefly just now. And it is precisely for the reason your Lordship has identified, and others, that I don't say that policy provides the answer.
Yeah.
If it be the case that I'm right on the first point, then the policy considerations, even if not considered in the way your Lordship has indicated in that authority, nevertheless provide support for that for which I'm contending. And I can't really put it higher than that.
No.
And I hope I've not sought to.
No, you made it very clear that to say it's a make-weight is slightly unfair, but we're in the area of a make-weight point.
Well,
all
policy considerations of that sort are relevant.
Quite.
I wouldn't quite accept make-weight, but your Lordship, I know what your Lordship means if I may respectfully say so. Yes. My Lord, there's just one last point in relation to the submission I've been making yesterday and today in support of my contention that this is principled and coherent, and it's a very short point. And it's this, that it is relevant to note that the Law Commission, as your Lordships will know, having read it, in 2007, came to the conclusion, having considered competing academic arguments and other material, that Chan Wing Siu had been correctly decided. If I could just give you the reference, because I know you will have seen it. It is Volume 1, Tab 13, page 423.
423.
423, my Lord. Paragraphs 3.133 and following.
Thank you.
And that's B423.
Yeah.
It is, my Lord. I'm so sorry. I keep forgetting to say the B. You're right.
I mean, it's in the first one.
Yes, it is. My Lord, can I then move to another subject?
Just going back to the New Zealand case, to see whether we actually need to read it or not. Did it take matters any further than the New Zealand decision in Gush, which was referred to in either Powell in English or Chan Wing Su, where again the court had to construe the meaning of the word probable in the Crimes Act 1961?
Well, my Lord, the answer is I don't believe...
It's been statute law in New Zealand for very many years.
Yes. My Lord, I don't believe it did, but I would have to look at the authority, so perhaps I cannot be bound to what
Do you
I've
know how
just...
far back the Crimes Act goes? We can look it up. But
No, I don't know that either, my Lord, I'm sorry.
1961.
Well, it was enacted in 61, certainly.
Yes.
But whether that was a codification of
that's
some...
the question.
Yes.
Yeah.
So, my Lord, moving then to the question, the next question, even if the current law is, I can use the word imperfect, I submit it does not follow that the board should intervene. And, my Lords, the first of several points I make is this, that there is considerable doubt as to whether any, and if so which, alternative would represent an improvement. So, for example, the Law Commission, again, in 2007, was not persuaded that the law would be improved by a requirement that the jury be directed in terms of probability rather than possibility, and it was for that reason that I mentioned the New Zealand case. Just for your reference, that is paragraphs 3.149 to 3.150 of the report. And the only additional point I make on that was that the Commission observed that the meaning of probable or highly probable was fraught with difficulty. I say no more than that, but respectfully support that. The second point that I make is this, that similarly, the various alternatives proposed by the appellant and Jogee raise as many or more questions than they answer. That may just be another way of saying what I've just said, but among other things that I submitted yesterday, I made the point that any sort of change, such as is suggested, could and logically would impact not only on cases other than murder, which everybody accepts, I think, but also, as I submitted, on basic accessory liability. My Lords,
If just on this, parasitic accessory liability is a fairly modern entrant on the criminal stage. I can't remember when the expression was first used. But if it, on analysis, is unsound, would there be any difficulty in the mens rea for crime B being any different than for crime A in relation to accessory liability? In other words, the standard mens rea would apply to all accessory offences as it had done for previous centuries. Would that, if one concluded that if one were persuaded the court had taken a wrong turn, would there be anything unprincipled or impractical in going back to what it had been and having the same mens rea for all forms of accessory liability?
forgive me, my Lord, but can I just get clear exactly how far that goes? My Lord says mens rea for crime A. Now, I mean, currently in parasitic accessory liability, there is obviously a requirement for D2 to have the requisite intention in relation to crime A. We yesterday looked at the requirements in respect of basic accessory liability. Is my Lordship suggesting that D2 should have some intention not only in respect of crime A, but in respect of crime B?
Yes, that's where the whole question of scope of venture comes in, and that's where conditional intent is so important.
My Lord, that, with respect, would be, if it was a requirement that he intend crime B, an extension which would go beyond the requirement which there currently is in the case of basic accessory liability. So if one thinks back to the three types of joint enterprise which were identified by my Lord Hughes in R and A, the first was paradigm common purpose. The second was, and I quote, where D2 aids and abets D1 to commit a single crime, as for example where D2 provides D1 with a weapon so that D1 can use it in robbery, or drives D1 to near the place where the robbery is to be done, or waits around the corner. Now in that case, you have a single crime, and the limit of the extent would be as I identified yesterday, namely it has to be an act of assistance which you do deliberately with intention to do that act, and you have to intend to assist. But you do not, my Lord, on authority, have to intend the outcome. Now, if my Lord's...
The distinction is intellectually possible, in practice very small, because you've got to have an intent to assist or encourage the commission of the offence, haven't you?
Yes.
Yes.
To assist and encourage.
In other words, you've got to have an intent to further the commission of the offence.
A contemplated offence.
Now, I agree that you can say that an intent to further the commission of the offence and the intent that the offence should happen are not precisely the same, but in the vast majority of cases they are going to be the same.
Well, My Lord, I'm not sure with respect. Put it this way, there will be cases, however large a minority it is, where they're not the same. Now,
Not many, unless, of course, you treat intention as synonymous with desire.
well,
Right.
In which case you come to the kind of case that Lord Evelyn
Yes,
referred to
yes,
in
yes.
Gamble.
Well, my Lord, I see.
The man who supplies the gun simply because he wants the money and doesn't care what happens to it.
Yes.
But the reality is that if you're a gun supplier and a crook and a hitman comes to you and asks for a gun, you know perfectly well, or you foresee perfectly well, what he's going to do with it. And in ordinary language, some would say you intend.
Yes, some would, my Lord. But, my Lord, there are only two answers that I can give. The first is that there is nevertheless a distinction on the authorities.
That's certainly true.
The second is that were one to do that, one would be asking far more than one asks effectively in the case of basic accessory liability, because, my Lords, the reason for the test that exists in relation to parasitic accessory liability is because it's not a single enterprise, there are two. And the intention, the primary intention, attaches to the first crime. Now, in the example my Lord puts to me, this would involve intention at two stages.
But it would involve, as used to be the case, an intention if the need arose or the circumstance arose to commit crime B. And that's why one gets all that discussion of that subject in the older cases. All I'm just questioning is, given that the ordinary rule is that has to be shown the accessory intended to assist or encourage the commission of the offence. If the offence charged is murder, why that rule should not apply? Did he intend to assist or encourage the commission of murder? That would include, it doesn't mean desire, and it would include a conditional intent, that is, say, we're taking guns out because we intend, if necessary, to use them.
My Lord, apart from the practical considerations as to just how a jury would ascertain whether in a parasitic liability case there was intention of that sort, it would be imposing an extremely high threshold. And the precise reason, the rationale for liability attaching in the circumstances which it does, based on intention to take part in crime A, coupled with foresight, coupled with participation, and thereby, as I submitted yesterday, tacit agreement, is that that is enough.
I don't follow why it would be imposing any higher burden than in any other case. If the charge is aided and abetted murder, what is especially high about saying that the standard test should apply to it?
Well, my Lord, I can only say, first, because the authorities do not, as I've indicated, require that in basic accessory liability, and there will be cases which your Lordship may consider are the minority of cases where there will not be intention
So
of that step.
what don't they require in basic? They require in basic an intent to assist
intention,
or encourage the commission of offence.
An intention that the outcome
No,
occurs.
an intent to encourage the...
Oh, certainly.
That's right. And I'm simply saying, if the charge in the indictment is murder, what is creating a especially high burden on the prosecution if the standard mens rea requirement is applied?
Well, my Lord, conceptually, it's going to be very difficult in a typical parasitic accessory liability case for the jury to infer intent where crime B is only contemplated. Now, bear in mind what my Lord says about contingent liabilities, but juries have an extremely difficult job inferring intent in an ordinary single crime.
What is so very difficult? If people go out with guns and bars to commit a robbery, what is difficult in the jury inferring that they took them there for a purpose, namely to use them if the staff resisted or if they needed to make a getaway.
Well, my lord, that's but one example. One knows in parasitic accessory liability cases that, as I indicated yesterday, D1 may only form the intention to commit crime B at some quite advanced stage. Now, up to that point, there may have been no basis for inferring on the part of D2 that very much was going to happen. But nevertheless, at some point, he does.
That problem arises in relation to foresight as well, doesn't it?
Well,
But can I just ask a related but equally fundamental question? Everything that you've said is predicated on the difference between basic accessory liability and parasitic accessory liability, as Professor Smith, I think it was, first called it. And I just want to think about whether, or want your help about whether the crime A, crime B analysis, which we've all in the past adopted as told, as instructed to do, really always stands up. It's easy, of course, if there's a criminal venture like a robbery or a burglary, and the violence occurs in the course of that. The wages snatch is a very easy example. But if you're talking about spontaneous mob violence, which a great many of these cases are, you can, of course, construct a crime A in the sense of an assault.
well,
But is that really a helpful analysis?
well, my lord, there has to be a crime A. That's the first point. Because
Well, why?
Well,
That's what I'm asking.
well, because otherwise,
Why does it make the difference in the spontaneous mob case?
well, my lord, the difficulty with the crime A, crime B analysis is that it perhaps masks the reality. What your lordship is talking about, and what I would submit, is that you're looking at a continuum of activity. That results in what we've been calling crime B. It is the totality of that, on the basis I was submitting yesterday, that amounts to the venture.
Yes, I see.
But you don't have to have a crime. What you're concerned about, surely, basically, is what is the venture or common purpose? That's the critical question, isn't it?
Well,
and it's how you define, or on what basis do you arrive at the ambit of it.
Yes.
I think the old law was that it was an objective test. You looked. There is an argument to say that the law modified itself and it became subjective, hence foresight comes in. But how do you define the ambit of the adventure by reference to that? I think is possibly the key question.
Well, my lord, as I submitted yesterday, very much echoing what your lordship's put to me initially there, in a paradigm case, there will be an identity of purpose and intention.
Yeah.
In any other case of joint enterprise, the question is, what is it that makes it a joint enterprise? And that can arise, on my analysis, at any point. And what I was submitting yesterday was that what constitutes it a joint venture is the identity between, on the one hand, the realization or foresight in D2, after which point, because he continues to participate, he has assented or agreed or tacitly agreed, and on the other hand, D1's intention to commit crime A. Now, in any continuum of activity, once that point is reached, there is a joint venture. Two things have come together to produce a result. Now, my lord, it's in that way that parasitic accessory liability, as explained in Chang Wing Siu, assists in determining liability, because in those circumstances, you can't easily fit it within any simple doctrine of common purpose liability. My Lords, that was effectively the submission I was making yesterday, and that's my answer to the question.
Okay, thank you.
My Lords, can I just say two things very briefly now under the head, again, even if the law is imperfect, it doesn't follow that your Lordships and my lady should intervene. Two things briefly in relation to what I'm going to call Ormerod and Wilson with respect suggestion, which is espoused by Mr. Knowles in particular.
Yeah.
They're very brief points. The first is that it's really blindingly obvious. Belief is a very high test. Now, unless that were to be construed as foresight of some sort, which would obviously be contrary to the accepted meaning, which requires, I think I can put it this way, a conviction of the truth, that is, as I say, an extremely high test, and not one which is required for the reasons I've submitted. But the second point flows from something my Lord Toulson canvassed, I think, on the first day, and really doesn't concern me, appearing as I do in this case for the Director of Public Prosecutions of Jamaica, and that is the possible suggestion that the Serious Crimes Act 2007 effectively might be seen as providing statutory authority for taking such an approach, in other words, adopting a belief approach. All I say, as I've already indicated, is that that would not be a permissible route in the context of Jamaica, and would, in the context of Jamaica, therefore, constitute, with the greatest of respect, judicial legislation.
Understand.
My Lords, to conclude under this head, the reality is, in my submission, that the law in this area can only properly be considered, and if appropriate, amended, in the context of a wider consideration of the law of murder, the categories of accessory liability, and indeed sentencing provisions, and in particular the mandatory sentencing provisions in the case of murder, and that has been the stance, for what it's worth from my perspective, of the United Kingdom government as recognised by the Justice Committee. The reason for saying that is only to introduce what I now want to mention briefly, which is statute law in Jamaica regarding sentencing for murder, which I touched on yesterday. Now, my Lords, just by way of introduction, it is not just the test for Category 3 or parasitic accessory liability, which is the focus of the criticism which it has received in some quarters, but, as Professors Wilson and Ormerod acknowledge, the combined effect of parasitic accessory liability in cases of murder and the effect of mandatory sentencing provisions, the result of which in some cases is one which is perceived as harsh. Now, the link with sentencing can, again, as the Law Commission recognised, but this time in its 2006 report, Murder, Manslaughter and Infanticide, have a distorting effect when it comes to analysing the basis of and justification for parasitic accessory liability. At any rate, what is clear, my Lords, is that there is a cogent argument to the effect that it is as much, if not more, the result of the sentencing provisions which produces the results which some say are harsh. Now, my Lords, that's the introduction. In Jamaica, which is obviously the only jurisdiction with which I'm concerned,
Yes.
murder is categorised for the purposes of sentencing. Your Lordships have the relevant statute it's the Offences Against the Person Act, Volume 2, Tab 33, B937.
Thank you.
Your Lordships may wish to have a copy of it to hand, but I don't propose, unless it becomes necessary, to go through it because the provisions are quite tortuous. What I'm going to do instead, if I may, and I know Mr. Knowles will correct me if I'm wrong, is to summarise the position. We have, in fact, set that out in our case at paragraph 111, which is page 425.
Thank you.
The even shorter version of it, my Lords, is this. In cases of what I'm going to call aggravated murder, because essentially it's categorised in two ways, a person convicted must be sentenced either to death or to life imprisonment. So, in other words, there is discretion in relation to the imposition of the death penalty.
Right.
person not in that category must be sentenced to life imprisonment or imprisonment for a term of years of not less than 15 years.
Right.
But in each case, life, either in the case of an aggravated murder or another case, or in the case of a term of years in a non-aggravated case, provision is also made for minimum periods or tariffs, which have to be served before eligibility for parole, as in the 2003 Act in this jurisdiction.
Understand? Yeah.
Now, my lords, it's clear from the legislation that Parliament had well in mind the different roles which may be played by different participants in murder, and legislated on that basis, since in the case of aggravated murder, though not other murders, it differentiated for sentencing purposes between, on the one hand, any person who by his own act caused death or inflicted or attempted to inflict GBH on the person murdered, or himself used violence on that person in the course or furtherance of the attack, and on the other hand, any other person convicted of the murder. My lords, that's section 2, subsection 3, which basically works by disapplying the provision that says you have to, in an aggravated case, be sentenced either to death or life imprisonment, and results in the case of a participant who didn't inflict the harm or do some other violent act in a sentence of life imprisonment.
Yes, I see.
Now, my lord, that was a clear policy decision, but equally,
So is the effect that if you come under 3.1b,
you come under 3.1b as the result.
and,
if you
and the
were,
consequence of that is?
that you then can be sentenced either to life or to a term of years of not less than 15.
15 years.
And if it's the latter, there's a reduced tariff period, which is 10 years.
Yep, thank you very
There's
much.
a scale on the tariffs. Now, equally, my lords and my lady, the clear policy of the legislation enacted as it was in 2005, that's by amendment in 2005, against the backdrop of the well-established law governing joint enterprise, and in particular what we're concerned with, Category 3 liability. The policy of the law is to the effect that in cases of non-aggravated murder, all parties to the murder, irrespective of the role they played, are subject to the same sentencing regime. But, as I've just indicated, that regime does give you the option of a term of years of not less than 15. Now, my lords, obviously these are sentencing provisions and have no bearing on what the test should be in the case of joint enterprise. And I do not suggest for one moment that such sentencing provisions can prevent the appropriate development of the common law. I would simply make 2 points. First, those various and carefully considered policy choices reflected in the legislation were made very recently in the light of, as I have indicated, clearly established and well understood law in relation to secondary and Category 3 liability. And therefore, any substantial change to that law would risk undermining the basis and policy of that legislation. That's the first point. The second point...
What's the sentencing regime for manslaughter in Jamaica? Up to life?
My lord, I think it is, but I'll need to, unless Mr. Knowles can confirm it.
And equivalent provisions for setting a tariff?
Well, my lord, I'm not sure. May I come back to the board on that? It may be possible to do it by the end of the morning, but otherwise I will simply confirm
We
the
can
position
probably look it up
in writing, if I may.
Yeah.
Yes. Yeah, I think Mr. Knowles may be right that he's suggesting that it's a maximum of life but determinate sentences, but I'm not sure.
As it is here.
Well, if that is the case, yes. My lord, can I confirm the position? My lord, the second point is that the reality here is that parasitic accessory liability sits, as we've submitted in our written case, embedded in what is an interlocking scheme of primary legislation, including the equivalent provisions in Jamaica to Section 8 of the Accessories and Abettors Act of 1861, long-standing common law, at any rate common law since Jang Wing-Sue, and including in Jamaica recent legislation which has been informed by that common law. Now, my lords, just on a point of housekeeping, in your bundle at Volume 2, Tab 32, you were meant to have a provision of the Criminal Justice Administration Act, which mirrored, up to a point, Section 8 of the 1861 Act, but the wrong section was put in. The position, in fact, is a little more complicated. I don't rely on these provisions in any way, but I ought just to clarify the position. A little more complicated in Jamaica than it is in this jurisdiction. The criminal justice...
What page is that?
Well,
Has it been put in?
My lord, no. My lord, what I'm doing, forgive me, is just outlining the position, and we are making available, and they will be available, copies of the provisions. But since I don't rely upon them for any purpose, can I just deal with it?
Just so to know which section it ought to be.
Yes. Well, my lords, as I was indicating, the position is a little more complicated in Jamaica, but the Criminal Justice Administration Act deals with the equivalent provisions of Section 8 of the Accessories and Abettors Act in variously Sections 34, 35 and 36. The complication is that it deals with accessories before the fact and accessories after the fact separately. As to people present at the scene, they're not addressed because they are still considered and charged as principals in the second degree in Jamaica, as I understand it. There is one further qualification, and that is that those provisions all relate to felonies. The distinction between felony and misdemeanor still exists in Jamaica. Therefore, there is also an equivalent provision in the Justices of the Peace Jurisdiction Act, and it's Section 6, which deals with what I'm just going to call summary offences. My lords, I'm very sorry you don't have the materials. They have now been copied and they will be made available, but I'm not making any submissions by reference to them. I'm simply correcting the fact that I gave the impression there was but one provision in my case, and we gave you the wrong provision.
Okay.
And I just want to ask one question which may simplify this. It's well understood in this jurisdiction that the Accessories and Abettors Act was purely procedural. It didn't alter the substance of the common law as to what an aider and abettor was. Authorities that easily found. May one take it that the legislation in Jamaica is similarly intended to replicate the common law?
Well, my lord, that is certainly my understanding.
So from that point
Mr. Knowles is agreeing with me.
So from that point of view, we don't actually need, helpful as it is for you to have identified it, we don't need to go through the statutory provisions.
My lord, you don't. I'm afraid this has flowed from the fact that we referred to a provision in our case.
Right.
And I just didn't want your lordships to think it was.
Thank you very much.
So, my lords, the final subject before I conclude very briefly is really just developing my submission that the appeals raise issues of policy which are ill-suited to judicial intervention and best left to Parliament, about which I've said a certain amount. Can I just summarise my position?
Can I just ask you one thing? It's clear why in Powell and English, where the last opportunity arose to...
I'm sorry, my lord, I didn't...
Sorry, it's clear from Powell and English
Yes.
where the opportunity arose, really, to change the law.
Yes.
Or put it on a different footing. And in the UK, there's been a lot of consideration since then, both the Law Commission and questions in Parliament. The position in Jamaica is what?
Well, my lord, I was about to address exactly that.
Oh,
Would
if you're
your
coming
lordship,
to that.
would your lordship bear with me just for
Of course,
just for
then
a
I'll ask you
moment,
the question.
And I will answer the question. My lord, so far as this head is concerned, the issues raised in both appeals are obviously highly contentious, and they divide opinion, at any rate, in the United Kingdom, my lord. And I will therefore come to Jamaica in a moment. Between academics, between offenders and those who represent them, and some of the families of victims, but also more generally, and the judiciary too, in some instances, my lords. Now, those questions which are raised engage any number of issues, but variously, and not exhaustively, issues of morality, criminal theory, justice, and policy. Now, the appellant's complaints are likewise bound up with wider, as I've indicated, heavily policy-laden considerations relating to the reach of murder as an offence and indeed sentencing legislation. Now, apart from the reasons of principle, which I have already addressed you in relation to, there are therefore in my submission strong policy arguments which can be made in all those circumstances for maintaining the status quo. The arguments on the Crown side of this debate would be arguments about deterrence, about prevention of more serious crimes, and about the prevalence of participatory and in particular gang-related crimes and so on. I've already mentioned all of that. But the last of those, gang-related crimes, is, as your lordships will be only too aware, a particularly acute problem in the Caribbean and also in Bermuda, where it commonly involves drugs and the use of guns. And, my lords, I simply make the point that public and political opinion is likely to differ between various countries as to the purpose served by Category 3 liability, its effectiveness, and its justification. And it's for all those reasons, in essence, that I submit that this is probably a matter for Parliament, not the courts. But as to Jamaica, my lord, no material has been put before the board to suggest that there is the same, or indeed any, debate on the subject in Jamaica. Beyond that, what perhaps I may be permitted to say on the instructions of the director is that there is no debate of the sort which has engaged the Law Committee, the Law Commission, the Justice Committee, and Parliament here in Jamaica. Now, I accept that is entirely on instructions, but it is in the context that no material has been put before you to suggest the obverse.
But in the consideration of this sort of law, and say in a law school in Jamaica, there's no discussion, no unhappiness of the kind we've seen discussed in the English. There is no, well, as far as you're aware, there's nothing.
So far as I am aware, based on my instructions, no. What I would add, we haven't burdened your lordships with them, but we have had a look at several recent Court of Appeal decisions in Jamaica, and all they show is the consideration and application of the Chang, Wing, Siu, Hui, Chi, Min, PAL, and English line of authorities.
And there's no evidence that in Jamaica there's concern that the law is producing a wrong result.
Well, my lord, subject to the very important caveat, so far as I am aware, and I have asked the question, no. One might have expected, if there were, the sort of material of which a voluminous quantity has been put before you in the context of the English appeal to have been produced. That's all I can say, my lord.
You wouldn't, of course, find that here in Court of Appeal decisions.
My lord, yes. But I'm not...
steered very well clear of it.
Yes, yes. Well, for that reason, we haven't really... all I'm doing is telling my lord that, that there's been no judicial concern expressed in judgment, so far as we're aware. Whether extrajudicially or not, I don't know. But as I say, more generally, based on my clear instructions, that this debate is not raging.
There have been no debate of the kind similar to that in the UK.
My lord, so far
as you're aware.
I really can't go further.
No, that's all.
If my lord had in mind any specific inquiry, I would
I just wanted to know, that's all.
Okay.
Well, my lord, I simply reiterate that we could make further inquiry if it would give assistance.
That's all I wanted to know.
Okay.
So, my lord, can I just say a few concluding words?
Of course.
Regardless of exactly how the law has reached the position it now has, that position is clearly established by a line of cases and can, if our submissions are correct, be justified as principled and coherent. Any change would potentially have far-reaching effects, not only on other areas of the law, but also in other jurisdictions. Moreover, at the heart of this debate lies a choice as to the balance to be struck between various competing concerns in determining who, other than the principal actor, should be liable and in what circumstances for the crime of murder. And bound up with that are the heavily policy-laden considerations to which I have alluded. And so a change to the test for parasitic accessory liability risks, in our very respectful submission, amounting to judicial legislation in what is a particularly difficult area, and also risks being a blunt instrument. And so, my lords, quite apart from the doctrine of precedent, the importance of which those considerations perhaps underscore, all of these are reasons for not departing from a decision or decisions reached at the highest level. Now, my lords, there was only one matter that I intended to deal with, which I was invited yesterday to deal with, and that is disposition, in the event that you were against me on what I'm going to call the main issue. Mr. Knowles and I are not very far apart, but he will tell you in what respect he differs. My submission would be that if you were against me in those circumstances, the appropriate course would be to allow the appeal, but not quash the conviction, because otherwise the consequence of release would flow from that. Direct written submissions regarding whether manslaughter should be substituted. Should you, having considered such submissions, conclude not, then I would ask that you remit the matter to the Court of Appeal for consideration of whether there should be a retrial.
Understood. That's very clear. Thank you.
My lords, unless I can assist your lordships or my lady further, those are my submissions.
Considering how many questions you had this morning, you've done very well to finish in time. Thank you very much indeed. Thank you. Mr. Pennington-Bent.
We're just going to reconstitute.
Of course.
Yes, sorry. Thank you.
Yeah, thanks.
Ms. Gary.
My Lords, may I begin with the summing up in the trial? Some short words in relation to that. And then my reply. I should say that my team have worked very, very hard listening to all the questions that have been asked over the last day and a half. And we know or believe that we can answer them all. It does mean I may be a little over 30 minutes, but not much.
No, I'm sorry. We have to finish at 12:30 and Mr. Knowles has to have his half hour.
I won't be any longer. In relation to the summing up, my Lords, at D, on page 135 of the essential documents, my learned friend Mr. McGuinness appears to have misrepresented the evidence. The summing up on page 135 of your Lordship's bundle at D reads as follows. We're talking about Johnny. At one stage, Nellie, that's Hersey, Eamon, that's Jogee, picked up a knife, and I think he was jokingly saying, I should go and shank him, and he was getting angry whilst he was doing this. But at that stage, Nellie, Hersey, was telling him just to forget it and to leave it. Mr. McGuinness took you to the ruling on the submission of no case to answer that suggested that without that passage, the Crown would have a problem. In our submission, the Crown does have a problem. Just think how that piece of evidence, my learned friend Mr. McGuinness suggested that it was the other way around. Of course, that was the reply in the defendant's interview. So the evidence from Naomi Reid was that Jogee picked up the knife. She thought he was joking about shanking someone called Johnny. So think how that applies in Milady Hale's peeling off cases. It's alleged that over 2 hours before the fatal events, the defendant is alleged to have said he would shank somebody else. That is disputed evidence. he effectively peels off. These two defendants were separate for 47 minutes before these events. His job is to come back and remove the principal from the household. No common purpose. The principal is removed. He goes back for an unspecified something. In a peeling off case, the youth is outside, can't possibly know what's going on inside, and ends up with a life sentence for kicking a car and waving a bottle. That is why Jogee's case is leading this race to the bottom of law. We make no real apology for our certified questions. Firstly, like Lord Toulson in his wonderful article, we were searching for an answer. And even if they are not amended, the second certified question, the overcriminalisation question, allows this court to consider all options. The solution, we say, having presented all those options to you, is Geoffrey Lane. My Lord Thomas asked, do we take Anderson or do we take Anderson and tilt it? My submission is don't tilt at windmills. My Lord, I'm old enough to have appeared in front of Christopher French as a High Court judge and to have been against John Machin. Our submission is that we need a direction that John Machin could give to a jury in Lincoln. My task in the next 30 minutes is to help you with any remaining difficulties as to the law. Please do not be lulled into inaction by Mr. Stevens' velveteen submissions or the suggestion that we stay with the status quo. Many of their points are dealt with sufficiently in our foundations document, which you have, and to the leading cases. I don't propose to take you to any of them, I'll just give you references.
Fair enough.
I'd also, as I say, will pick up on some of the points that your lordships have made. Firstly, the key question, what must the court require of secondary parties? Mm-hmm. How can the criminal law have a practical and effective, how can we have a criminal law that is practically effective and coherent in theory? The simple answer is that the secondary party must be shown to assist or encourage each crime that the secondary party is charged with, and that the secondary party performed his conduct intentionally, knowing or believing that the principal would commit a crime and intending to assist the principal in that crime. This simple test, not fairly simple, simple test, removes the tangent of Chan Wing Soo, and it returns us to the law that has served us so well for hundreds of years. That is an amended version of the trial judge's direction in Anderson alone, but understanding Anderson in the light of Johnson and Newden, as their lordships did in Maxwell. In short, it brings us back to real first principles, identifying essential matters of fact and intention. Second, the physical acts of secondary participation are simple. As regards any crime, the secondary party must be shown to have assisted or encouraged it. The great merit of our proposed return to established and traditional secondary liability is that the issue is simple and jury-friendly. The prosecution must prove some assistance or encouragement for every crime the secondary party is charged in connection with. It was of great interest to hear both of my learned friends for the respondents suggest that the law currently requires that in parasitic accessorial liability, the secondary party assist or encourage the commission of crime B. That at least was one of the things that they said in describing how the secondary party must participate to show authorisation, that they suggest completes that mere test of foresight. And that mere test of foresight is the only express fault element that parasitic accessorial liability currently asks for. If one takes the leading case of Powell, at page 14, Lord Steyne says crime B need only be in the course of crime A. Frankly, that in itself, we suggest, is a dangerous development of the law. It is an unfocused development of the law. At one point, it appeared from the submissions that they made that merely assisting or encouraging with crime A is always sufficient assisting or encouraging of crime B. And that, in our submission, cannot be right. Over and above that, no authority supports them. My Lords, you don't have it, but the Crown Court Bench Book of 2012, on page 44, merely says that the other person went beyond the shared intention. There is in parasitic accessorial liability no requirement that the secondary party assist or encourage through principles further acts, further criminal acts. Thus, we suggest that my Lord Toulson put his finger right on the pulse when he asked for a direction from any judge or academic on what precisely the secondary party must do to participate after foreseeing that the principal might commit another crime. Mr. McGuinness could think of no example. In truth, that's the point. The courts don't ask for it. And they don't ask for it because that's the purpose of parasitic accessorial liability. It deems that assistance or encouragement. It doesn't prove it. To assume responsibility for crime B rather than establish it. There is, we submit, certainly none that we found, no reported case where a prosecution failed or an appeal was allowed or even sought directly on that point, because it's apparent that the courts in our submission have not made it a requirement. Indeed, the Law Commission itself, in its report of 2007, said there was no requirement that the secondary party assist or encourage crime B, which is the very point Mr. Stevens is against. The only academic who has noted the point in our submission is Dr. Dyson, who provides the Foundation's document information that you have from us. Many academics have noted the absence of proof that the secondary party assisted or encouraged crime B. References we could provide should you need them. But what he said, when he did point in 2007 to the lack of a test for assistance of encouragement of crime B, he suggested at the very least crime B should be directly related to and arise out of the commission of the first offence, noting that such a test has been implied in the past but not set out in detail, and my Lords have that in the case of Gamble in Northern Ireland in 1989. We haven't supplied you with that article from 2007, but we can. Gamble is in Volume 1 at B606.
Yep.
We submit that reinstating the requirement of assisting or encouraging also helps to refocus attention on the core question, and this is my Lord Thomas's question: what is the scope of the common purpose? It was indeed my Lord Toulson's question yesterday as well. We think the answer to the question is this. One, and there are a few questions, first of all. How can it possibly be described as a common venture merely because one party foresaw it? What of the principle? Need the principle foresee the new crime to make it part of the common purpose? Or need the crime simply happen later, including crimes of strict liability? What of any other secondary parties? Are there multiple different ventures for different combinations of secondary parties and principles? Is there actually any sense of a common purpose, or is an individual liable for what he foresees, even if no one else foresaw it at the time? Indeed, some of those purposes may directly contradict each other, but Mr. Stevens implied they would all be part of the common purpose. how in everyday language can foresight equate with purpose? That was the very problem that Lord Mustylin-Powell raised, and he dismissed that very suggestion.
Yep.
The correct fault element, the third point we wish to make, is the correct fault element of secondary participation is also simple. Its core requires the secondary party to know, believe or intend that the principal will commit the relevant crime, and the secondary party must then intend to assist in the principal's commission of that crime. There are 5 points. 1, the mens rea for secondary participation should, in our submission, be returned to the track that it was on in the trial judge's direction in Anderson. That is, combine clear guidance on the law with the value of jury decision-making. That was essentially least practically important, that the secondary party must intend his act of assistance or encouragement. What that means is it's not accidental. That the secondary party knew or believed that the principal would commit the crime or type of crime, whatever crime it is. In my earlier submissions, I referred to this as crime N, to distinguish it from a sequence of crimes, crime A and crime B.
Presumably it doesn't have to be a first crime at all if they're engaged on doing something.
Yes, it's just a crime.
No, it doesn't even have to be a crime. If they're engaged on doing something which isn't a crime, and then a perpetrator then moves on to commit a crime,
Well,
then the same considerations would apply in it.
yes, the prosecution have to prove the crime and the culpability.
As Lord Hughes says, it doesn't have to be a crime A.
No. It's, in our submission, it is just a crime that the prosecution have to prove beyond a reasonable doubt, and the culpability point is that it has to be what's identified as a crime. Here, no such thing. So we submit, in terms of the fault element, or the mens rea, that the secondary party knew or believed that the principal would commit the crime or type of crime, whatever crime it is. That the secondary party intended, by his action, to assist or encourage the principal to commit the crime. My lords, in practice, we accept that most secondary liability cases might involve a common purpose. And that's why the language of common purpose is so prevalent. I talked on Tuesday about the scope of the common purpose or plan or design. But if my lords look at our foundation document, paragraphs 70 to 79, we made it clear back then that the secondary party need not intend the principal to commit the crime. The issue shows one of the limits of conditional intents. Not all conditions are meaningfully culpable. My Lord Hughes asked Mr Stevens for an example of a case where the secondary party does not intend the principal to commit the crime. The example we give you is the National Cobalt and Gamble in 1959. That was the Weybridge operator case, and the Weybridge operator focused on his task, not on public safety. He said he didn't care in the slightest whether the principal, the driver, drove on public roads with an illegal heavy load. Another example might be, that we've come up with, would be, just bear with me, the secondary party pleading and begging with the principal not to assault the victim, but ultimately leaving a bulletproof vest where the principal would find it, just in case the principal went ahead with what he'd pleaded with him not to do. If the principal did go ahead, the secondary party is liable under basic accessorial liability without having had a common purpose with the principal to assault the victim. The secondary party must intend to assist and encourage the crime identified by the essential facts as he knows them to be. Two, foresight does not mean authorisation. I'm not going to repeat what I've already said. But if continued participation is shown, as it should be, but is not now, it would show an intention to assist the principal, not some nebulous concept of authorisation. Clearly, Mr McGuinness and Mr Stevens have to argue that foresight does equal authorisation. But it's important to note that as a term of art, authorisation is not used in the rest of criminal law. And again, we've dealt with this in our foundations document at paragraphs 256 to 291.
Thank you.
My Lord's asked about reluctant acceptance. Mr Stevens at one point suggested, my Lord Neuberger clarified, why is reluctant acceptance, our point here, why is reluctant acceptance not simply reluctant intention? Mr Stevens noted that there were many things he had to do which he didn't want to do. He did them reluctantly. We all sympathise and we empathise with him. But clearly, Mr Stevens would say that when he does the things which he doesn't want to do, doesn't he do them intentionally in any event? Does he only do them with foresight followed by acceptance, or does he in fact do them with intention, even if he doesn't want to do them? And we had the example in Milady Hale's language about going to Manchester. If he doesn't want to go to Manchester, he's doing it unintentionally. In fact, a reluctant intent is still an intent, although there are many good reasons to go to Manchester. The other analogy we can think of is this. My learned friend Mr McGuinness, let's say he foresaw that this court might find against him in this case. Does he in any way authorise the court to decide in that way by continuing to participate in this hearing? As a matter of natural language of authorise, it shouldn't matter that our case today is not an unlawful act to begin with. It shouldn't matter that the court does not require Mr McGuinness's authorisation, since the principal actor, PAL at the end, certainly does not require the secondary party's authorisation for the principal to be liable. In addition, how can what is at very best evidence, we submit evidence of intention, not authorisation, become a rule of law? If participation towards crime B has in fact been shown, then physical participation can only ever be evidence of the mental state. It can't be that there's anything special about parasitic accessorial liability, some sort of gateway that shows a disregard for the law. Since, as we have pointed out in our foundations document, and indeed I believe Mr Stevens admitted, mere foresight has already been carried over into basic accessorial liability. It was the point that I made on Tuesday about everything being subsumed. We submit there's no justification for foresight or authorisation, and they should be both expunged, one or both of them both the same. 3, there's been a lot of discussion about conditional intention. My submissions on Tuesday was it's not the answer. Perhaps what I should have said was it's not the complete answer. But the utility of conditional intention has been noted more than once over the last couple of days. And what my submission was on Tuesday, that the concept risks seeing clear conditions in what were possibly unclear circumstances. It might be of use if culpable conditions are clearly demarcated, so it's the answer in some cases, but not all. The example Milady Hale gave was, we'll use it, the weapon, only if we have to. Milady also used something similar in the case of Sake in 2007, on participants agreeing to go ahead even if the victim doesn't consent. For the felony murder rule, as Mr McGuinness put it, my Lord Hughes, the constructive malice rule, my Lord we've set out in our foundations document the context in which that change started the route towards parasitic accessorial liability. My Lady Hale asked why was that rule removed in 1957, and my Lord Hughes gave a response. My Lord Hughes's response is consistent with the Royal Commission on Capital Punishment. We haven't provided that to you, but if you wish us to, it's Command Paper 8932.
Thank you.
We submit the more interesting change was in 1968, the Criminal Law Act of 67, Section 1, which abolished the distinction between a felony and a misdemeanour. We deal with this in our foundations document at paragraphs 16 to 21 and 89 to 93. The common purpose rule made principals out of all the parties to the common purpose to commit a felony. That avoided technical procedural rules requiring a principal to be convicted or outlawed before an accessory could be tried. That was the effect of the common purpose rule. I suspect I'm telling my Lord Chilson something he knows very, very well. But its purpose was to deal with multi-handed crimes. It's that purpose that we still see today when we talk about common purpose. That the defendants intended the crime to take place. We see it in the language of being in it together, when the prosecution has not found evidence to specify what the defendants actually did or what fault they had. So in a sense, keeping parasitic accessorial liability undermines that statutory change. 5, my Lord's asked about, and it's in the submissions, how do you know the future? That was the question, I think, in some of the written cases. As a result of us presenting that line of authority, Johnson and Newden, that doesn't really appear in Powell and English and some of the cases that discuss parasitic accessorial liability. We've had some discussion about whether you can know future events. And in Johnson and Newden, the excess payments had already occurred, so they could easily be known. It isn't a problem. Knowing future events is not a problem. Thinking it's a problem is an illusion. That's why I used the phrase twilight zone, because we use the phrase in the courts all the time in relation to knowing the future. We can give you some examples. Johns at B150, in the summary of the facts, according to the majority of judges, and I quote, the applicants also stated that he knew that Watson would not let Morris get on top of him. So the secondary party knew that the principal would defeat Morris in a physical confrontation in the future. Slack, B1775, Lord Lane, in explaining Maxwell said, and I quote, he, the secondary party, knew that others who were following his lead car were armed and that they would make some terrorist attack, whether by guns, bombs or incendiary devices. Whether by guns, bombs or incendiary devices, he did not know. Describing the secondary party as knowing that one of 3 things will happen, not merely that the alleged terrorists wanted to do it, intended to do it, or planned to do it. Knowledge of future. In a statutory conspiracy under the Criminal Law Act of 1977, Section 1, subsection 2, dealing with conditional conspiracies, the parties are not liable unless at least 2 parties to the agreement intend or know that that fact or circumstance shall or will exist at the time when the conduct constituting the offence is to take place. That is, in one form, a conspirator knows that in the future a fact will exist. Those are just the few examples we've been able to come up with over the last couple of days. Secondly, what is knowledge in any event? As a common word, it's often given a common meaning by juries. But just as intention has a technical meaning in law in the background, so does knowledge. The closest practical definition is justified true belief, a belief which one has grounds to hold and which is in fact true. It is nonetheless a form of belief. There is no meaningful difference in our submission in culpability in assisting or encouraging the principal, knowing the principal will commit a crime, and assisting or encouraging the principal, believing the principal will commit a crime. The point is simply that the secondary party, in language that we are used to, knowing or believing in the principal committing a crime, is therefore a sensible and logical test that we are already using.
I should point out you're about 3 minutes short of your half hour.
Yes, well, I've made a number of submissions about removing the parasite from criminal law. I can summarise, that was the next passage of what I had to deal with. The language of parasites we submit are very, very difficult, and adopting intention or going back to intention forces a jury to stop and think. In particular, on that topic, I'd invite your lordships to look at paragraphs 198 to 207 of our Foundations document. Perhaps I can deal with it by a quick metaphor that Mr. Knowles talked about jumping tracks in error. We would submit that Sir Robin Cook's opinion in Chan Wing Soo caused the law to jump the tracks. Like any good train line, and I haven't been on one the last couple of days, but secondary liability has two tracks: physical acts and fault requirements. Chan Wing Soo, we say, jumped the fault track in complicity. Suddenly, the secondary party need only foresee what the principal might do. We say that's a misreading of John's, but we also say that Chan Wing Soo jumped the physical contribution track as well, so that the law is currently travelling on a monorail. My Lord Toulson, I move on now to the point that my Lord Toulson made in relation to the Serious Crime Act. If my Lord Toulson is suggesting that Parliament has, to an extent, given a lead by providing a higher fault element than we currently have in parasitic accessorial liability, the point that I make is that my learned friend Mr McGuinness was wrong on the law, and the fault element is intention or belief in section 44.
Yep.
There is a proper distinction between murder and manslaughter. I have three final very short points to make, if I may.
Yes.
The formulation of secondary liability presented in our submission that we have presented has merit to require the appropriate charging of murder and manslaughter. If my lords, we've set this out in a model direction, which I'll come to in a moment. But one issue that was identified by your lordships is that even where the secondary party is charged with murder, where the principal is killed in a more dangerous way, such as with a knife instead of wooden sticks, we concede that the secondary party must still be liable for the death unless the principal's act was of such a kind to break any connection between the assistance and encouragement and the principal's causing of the harm. The specific use of the causation doctrine, I have the same submissions really. It can work in some cases, but it isn't the complete answer. The production of a more dangerous weapon of itself will not automatically break the connection between the secondary party and the harm the principal does. It's a matter of fact and degree for the jury, just as it is with any test of causation. It should be noted that the forms of evidence may vary significantly in assistance and encouragement cases, but the central point still stands and goes back to Plowden and his commentary in Saunders and Archer in 1575 in our Foundations document in paragraphs 81 to 85. It was clearly what Anderson Morris was talking about. I want to deal just briefly with group violence. aside from cases of shared intention, as my Lady Hale notes, what do you do when you can't prove who killed the victim?
Yeah.
At this point, the law has a choice. Have rules which acknowledge what responsibility and culpability can be shown for that death, or have rules which deem culpability. The simple fact is that if you can't prove that there was a murderer who the secondary party assisted, however many secondary parties there were, knowing, believing or intending that the principal kill, the appropriate course is to make all relevant people liable for manslaughter.
Yep.
If the prosecution can prove they contributed to the death. If you can't prove that each of them assisted or encouraged another to kill, they are by definition not connected to the death and can only be liable for their individual crimes, affray, violent disorder and so on.
If you want to introduce your model direction, you better do so now, because you're
Yes, I hope that you have copies
into injury
of it.
time. Yep, we do.
I'm not going to read it to you clearly.
No, you're not.
We say, contrary to Mr Knowles's version, please don't use common enterprise or PAL. The phrase is secondary liability. We say it's a route that the jury can follow. Mr Knowles's version identifies why authorisation doesn't work, and where conditional intent, oblique intent and causation and so forth fit in is on the second page.
Well, we're very grateful to you and those who helped provide this note. Thank you.
I simply finish with this, applying the law as set out to Jogee's case. He did not, in our submission, assist or encourage Hersey to kill. The best that can be said of the prosecution's case is that Jogee waved a bottle and said something from outside at some point without it being clear what he could see of what was going on inside. It's also unclear what he might have said. And apparently he was also outside texting and damaging a car. The evidence simply was not good enough on any formulation. He did not know, believe or intend that
I
Hersey
think
would
we have
kill.
been over this.
Thank you.
Ms. Garrett.
My Lords, I perhaps leave you with this. In this court, your Lordships have a legal trail. You are being asked to answer your own question. On the back of that leaflet, there's a case you have to judge. 2 boys are stealing from a sweet shop. A third acts as a lookout for the police. The police catch all 3 of them. They were all part of the crime. They needed the lookout, but he didn't do any actual stealing. So should he get the same punishment as the others? Take a vote with your friends and family and circle your ruling. My Lords, we invite you to quash his conviction. Thank you.
Thank you very much, Ms. Gary. Mr. Knowles.
So sorry.
Yes. Yes, my lords and my ladies, some points on the specific grounds of appeal, if I may, and then some points on the broader issues. On the judge's joint enterprise direction, Mr. Stevens accepted that a PAL direction was required, and in our submission that was a correct concession. This was a robbery and a murder. It had 2 distinct component parts. Mr. Ruddock admitted, as your lordships have seen, a role in the robbery, but denied in terms having anything to do with the murder. However one interprets that Jamaican phrase, its sense is clear. It was nothing to do with me. The issue for the jury, therefore, we say was this: was he responsible as a matter of law for the murder? The jury may have concluded that the common purpose was the robbery only. We say that, therefore, required the jury to be correctly directed as to the circumstances in which he would be guilty of murder, i.e. foresight that Hudson would use the knife to kill or cause grievous bodily harm. Mr. Stevens conceded, I think, that at a minimum the judge's PL direction, such as it was a potential problem area. We go further and we say that it was plainly deficient, and your lordships can't be sure that the jury understood and applied the law correctly on what the judge said was the most important aspect of the case, see at page 128. We say the deficiencies, or the principal deficiencies, were these. Nowhere did the judge direct the jury in terms that they had to be sure that Ruddock foresaw Hudson would use the knife with intent to cause grievous bodily harm or to murder. Now, true it is, as my Lord Hughes put to me yesterday, the victim's throat was savagely cut, and it could only have been done by Hudson with intent to murder. I would accept that. But the issue for the jury was whether Ruddock knew in advance that that was the way in which Hudson was going to behave. That was what they had to be sure of. In other words, they had to be sure that Ruddock knew there was a possibility that Hudson would use the knife with at least intent to cause grievous bodily harm. And as I've said, nowhere were they given that direction.
Understood.
What we say, the judge referred to a particular intention, but your lordships have my point from Tuesday. We say in the context of a complex area of law, it was necessary for the judge not to be slightly Delphic as to what the ingredients of liability were, but to actually specify them.
Yep.
Bear in mind, this was an oral summing up. It wasn't the route to verdict. It would be inconceivable in an English trial now that any case based on parasitic accessorial liability would be dealt with otherwise than in writing. That's not the practice in Jamaica, for better or ill. But what it does mean is there has to be a very clear direction if it's to be given orally, and we say it wasn't in this case.
Understood.
What we say the judge should have said was something along the following lines. Members of the jury, if you conclude that Ruddock either did not or may not have known that Hudson had a knife, or if he did, you conclude that he only foresaw that it would be used to frighten the victim perhaps and not kill or cause grievous bodily harm, or he may only have foreseen that, then he is not guilty of murder. Something along those lines we say ought to have been given.
Yep.
On the question of knowledge of the knife, Mr. Stevens submitted that you could read an admission of knowledge on the part of Ruddock into the Jamaican verbal, Anna me told you, cut his throat. I respectfully submit that that is reading that too far. To read an acceptance by Ruddock that he knew that Hudson had a knife, we say that can't be derived from that statement. There was also, we say, a deficiency in that no fundamentally different acts direction was given. That may be a component of what I've already submitted, but certainly we say this was a case. Given there was just simply no evidence other than the admissions, that it was necessary for the judge to give the jury the full direction. Also, I respectfully adopt Lady Hale's observation that on any view this was a confusing direction. It is not clear, even on multiple rereadings, where the judge is referring to the robbery as the offence. He talks about an act. It's not clear where he uses act, whether he's talking about the robbery or the murder. The whole thing, we say, is very unclear. And the confusion arose in part because the judge, taking his lead from how the prosecution were putting the case, which was this was a common purpose to rob and murder, he then segued into parasitic accessorial liability, but did so in a way that didn't make clear that they were two distinct bases of liability with distinct ingredients. And what one gets, therefore, in the direction is a melding of the components in a way that we say resulted in uncertainty.
Yep.
Lord Hughes made the point, or put the point to Mr. Stevens yesterday, that the defence, of course, as you've seen from the unsworn statement, was I wasn't there. We say it wasn't enough for the jury simply to reject not there to convict because of the terms of the admissions. If the jury rejected not there and took the admissions at face value, they then obviously, as I've said, had to have a direction about how to regard them. So that's what we say on joint enterprise. On the hearsay point, I can be even more brief. I think without doing injustice to Mr. Stevens' submission, his submission was, well, this was admissible because it provided the context for the second admission that Mr. Hudson was alleged to have made, namely, I tied him up, but Hudson did the killing. We say with respect that Mr. Stevens' analysis doesn't meet our complaint for the following reason. It's plain from the summing up, for your lordship's note, 146, the admission was not dealt with by the judge as being a response to it being put to Ruddock what the lady had said. If you look at the summing up at page 146, the judge specifically says it was some time later, after the lady's statement being put to him, it was some time later after he'd been cautioned, and it was in response to the caution that the admission gets made, not in response to being taxed with the allegation that the lady made in her statement. So as a matter of fact, Mr. Stevens' reply just doesn't work because it wasn't the context for the admission. And we say that that is therefore a complete answer.
Yep.
So we say the lady's statement simply wasn't admissible on any basis. In the absence of any application to discharge the jury, and there was none, and I accept that, what the minimum the judge should have done was to give a clear direction to the jury. You must ignore that. You shouldn't have heard it. I'm directing you as a matter of law. It has no evidential value. Put it out of your minds. But as I showed you on Tuesday, although the judge did say, well, she's not a witness, etc., he then went on to specifically direct them to this aspect of the evidence as to say, you will want to think about that.
We've seen that, yes.
Members of the jury. So he gave a reverse ignoring direction almost. The prejudice, and this is perhaps the real point, the prejudice we say is obvious, and there are two components. On one reading, this was an allegation by the lady that she had witnessed both defendants committing the murder, and that was the very issue which the jury had to determine, was Ruddock party to the murder or not? Well, I see my Lord Hughes' reaction. The way the evidence actually came out may not naturally bear that meaning. We say it does, but I can see the counter-arguments. But the way the judge dealt with it in his summing up, and bear in mind, that was the last thing the jury heard before they went to deliberate on their verdict. They did this to the lady, they did this to Mr. Robinson, was how it was left to the jury. So if it was an inaccuracy in the summing up, it was an inaccuracy in the summing up, but that was how it was put to the jury. And we say it did create the potential for prejudice because it would have instilled in the jury's mind, here was a witness. And perhaps a lesser point, that they also did something to the lady, was bound to raise questions in the jury's mind. Your lordships know, as a matter of fact, the allegation was of rape, although I accept the jury didn't know that.
Yep.
But it would have been a short stretch for the jury to conclude these men also committed another crime against this woman of some unknown type. So for both of these reasons, whatever your lordship say on the broader issue, we say Mr. Ruddock's conviction can't stand. So coming then to the broader issue, if I may, we make the following points. At the outset of his submissions, Mr. Stevens suggested, somewhat faintly perhaps, but he suggested that joint enterprise, PAL in its Chan formulation was not new, and that there are traces of it in the old writers. We respectfully disagree. The old writers were working at a time when I said in opening that the law was painted in very broad brushstrokes, and foresight and intention were just not understood in the same way that we understand them today. Felony murder also existed, and that overlay makes it very difficult to project those old writers and principles onto the modern law. They're of interest, they are of historical interest, but in our submission of little help in resolving the issue that your lordships and my lady have to grapple with. Mr. Stevens also, as a large part of his submissions, and quite rightly, but as a large part of his submissions, he outlined the policy justifications, the rationales that are now put forward in the Law Commission and elsewhere for PAL. But there's a lot of learning the other way, much of which we've included in the bundles. So we say, given that there are policy arguments both ways, that is perhaps not the most helpful analytical tool for your lordships to resolve the issues that have to be resolved on this case. It is notable, for example, that the Law Commission's defence of Chan, if I can call it that, isn't done by reference to looking at the principles and Johns and how it was that it emerged from the case law. It takes it as a statement and then seeks to justify it. Well, we say that puts the cart before the horse. And the correct analytical method is the one that I have sought to suggest to your lordships and my lady you should adopt, is to look at the roots of it, look at what the law was in the 60s, look at the development, which is how I dealt with it in my submissions, and let's try and peel away how it is Chan came to be decided in the way that it was, rather than let's take it as a starting point and see if we can defend it or not defend it. Yeah. So coming to Chan and how it was, and how it came to be, and how it came to be picked up then in Powell and Daniels, we submit that the more yesterday and the day before, the more we looked at the basis and foundation of the Chan principle, which elevated what had been a rule of evidence into a rule of law, and that is its effect in short order. It turned a tool that the jury could properly use to determine the scope of a joint enterprise into the scope of the joint enterprise. But the more we looked at the underpinnings of it, in my submission, the more clear it became that the foundations are in fact extremely weak, and that the cases that underpin it, and I'll come to John's in a moment because that lies at the heart, but we say that in none of the cases on proper analysis was there any articulated principle or anything close to it which justified, with respect, Lord Cook's analysis of it and the subsequent analysis in Powell, and then in McAuliffe, the 1995 Australian case that we looked at yesterday. As I think it was my Lord Toulson observed, it all comes down to Johns in terms of the justification of Chan, or what's said to be the justification for Chan. And it's therefore Johns, we submit, that one does have to look for the underlying principle. We submit, and I won't go back to ask your Lordship to turn up Johns, we rather did it to death, but we say it's a vain search. If one looks in Johns for a principle statement, it's a vain search. We respectfully adopt Lord Toulson's comment yesterday to Mr McGuinness, quote, "It is difficult to see that contemplation has a jurisprudential foundation in Johns," and we respectfully agree with that observation. And we respectfully agree with it for the following reasons. Johns actually was a common purpose case in the traditional sense, and self-evidently so. It was almost the paradigm case of a common purpose. Two men on a criminal enterprise, and one says to the other in terms, if there's any nonsense, oh, I'm not going to stand for any nonsense, and they both know he's got a gun. It is the paradigm common purpose case, and could have been dealt with by the trial judge on ordinary common purpose principles. If I need to make good that reference, see the, I think the Americans call it the pluralities judgment, but the judgment of Mr. Justice Mason, Murphy and Wilson, paragraph 6, he said he wouldn't stand for any nonsense. I know he was quick-tempered. The next point we say Johns doesn't provide a proper foundation is the issues were couched in such a way to assume that some level of foresight was sufficient. And the real debate was, is it probability in a better than 50% chance, or is it a realistic possibility? That was the context of the debate. But that some level of foresight was sufficient was just assumed. And it is said in paragraph 9 by the three judges who gave the main judgment, that was conceded by counsel. Now, the reasons for the concession, one can speculate. I've offered the suggestion on Tuesday that it could be because in Australian common law, including in New South Wales where Johns was decided, foresight is sufficient mens rea for murder. And whether that somehow infected the thinking and led to the acceptance of the concession, we don't know. But the broader point is this: one has to be very, very careful in this area in automatically assuming that the common law principles that are in play in these other common law jurisdictions are the same as in England, because they're not necessarily the case. We looked up, we haven't supplied it, we can do, we looked at the Court of Appeal decision in Chan Wing Sue, the Hong Kong Court of Appeal. And that's very interesting and does bear some study, because in Hong Kong, Chan Wing Sue in the Court of Appeal was also decided on the basis that in Hong Kong at the time, foresight was sufficient mens rea for murder. So although that wasn't the basis of Sir Robin Cook's judgment, I accept, the broader point I make is one needs to be very careful in looking at these other authorities, because even for the principle, the mens rea requirement is not the same as in the United Kingdom. And therefore one must be very cautious about automatically reading across into the secondary context principles such as that. We say, therefore, that Chan has unsound underpinnings. And if we're right about that, then the whole foresight contemplation principle as a rule of law, giving rise to a jury direction, it is sufficient to convict for murder if you are satisfied that the secondary party foresaw or contemplated. We say that whole principle is unsound also. Powell obviously relied heavily on Smith and Chan. Now, Wesley Smith I looked at. It was the beginning of what Lord Hutton said was a strong line of authority. And I won't repeat, but your lordships, I'm sure, have my submissions well in mind from Tuesday. We did it to death. It was an extempore judgment of a 5-judge Court of Appeal, I accept, but it was an extempore judgment which did not articulate a principle that contemplation or foresight on the part of a secondary party was sufficient to found liability. It was a straightforward, common purpose case which was decided on the basis that, having regard to the particular facts, namely an attack on the bar and the bar staff, the jury were perfectly entitled to conclude that the use of the knife by Wesley Smith's co-defendant was within the scope of the common purpose, because the common purpose included attacks on people as well as property. And that is all Smith stands for, in my respectful submission. And to the extent that weight It was taken as the foundation and weight was put on it in Johns as justifying contemplation because Smith is referred to in Johns, and insofar as weight was put on it in Powell, we again say it can't bear that weight. Now, interestingly, when Mr. Stevens took you to McAuliffe, we see that, in fact, the reasoning is rather circular on this issue. He sought to derive support from McAuliffe. McAuliffe is an important case because Lord Hutton in Powell refers to it no less than 3 times, at the beginning, in the middle, and at the end of the section of his judgment dealing with the first question in Powell. The references are in the law report 20, 21 and 27, electronically from a lady, or for those following 3525, 3526 and 3532. But as we saw yesterday when we looked at it, the basis for McAuliffe is Johns again. So we have Johns underpinning Chan.
McAuliffe recognised that Chang couldn't be supported by Johns.
No.
And McAuliffe then followed Chang.
Yes.
Yeah.
Sorry, yes, that's what I was aiming to say, perhaps inaccurately, that Johns is relied upon in Chan. Chan and McAuliffe are relied upon in Powell and Daniels, but when we look at McAuliffe, the basis of McAuliffe is Chan and Johns again. So there is an element of circularity and mutual support. There is an element of it.
Yes, I see.
So that is why we say that your Lordship's Milady's analytical approach should be, what was the genesis? How did this rule come about, this new rule, as Lord Toulson describes it in his writing? How did this new rule come about in 1985? And we say, if you search for a principal basis, you don't find it. Just briefly back to the Law Commission and one additional point. Just so you know, it's quite right that the Law Commission in 2007 thought that Chan was correctly decided, and they said so in terms, and I obviously don't dispute that. When the Justice Committee looked at this issue in 2012, I think it was, they also said that if the law was looked at again, it should be looked at on the basis of the Law Commission's upholding of Chan effectively. But that position's now changed. When the Justice Committee looked at this issue again last year, they've changed their views on it, and they are recommending that the Law Commission look at it again, but not on the basis that 2007 provides the right starting point. It's a small point, but just so your Lordships know. You have my point about other jurisdictions. The mens rea requirements and principles are not necessarily the same, and so there is a real caution as to that. On the issue, and I'm coming to the end, on the issue of whether this court should intervene or whether it's properly a matter for Parliament, we say that this is comparatively recent judge-made law with an insecure underpinning. And if I am right, and this is why I emphasised it in opening, we're not saying the law's right, please change it. We're saying the law very clearly went off on a false branch, and therefore it is open to this court, entirely in accordance with orthodox principles, to make a correction. And I don't say this facetiously, Mr. Stevens' in terrorem arguments as to the consequences if the law is corrected, the common law can easily adapt and develop in precisely the same way as it has done around the Chan principle. If it was thought, the short point is this, if it was thought right to create a new principle of law in 1985, whether or not it was appreciated in its newness, we certainly appreciate its newness now. If it was right to do that, then it's right to correct it if an error was made. Mr. Stevens sought to draw comfort from what he said was the symmetry between PAL and basic accessorial liability, and he pointed to the fact that in basic accessorial liability now foresight had become the test, see Rook and other cases. But again, that circular reasoning, if I invite your attention to the Jogee Foundation's document, Dr. Dyson's document in section 6, there is a careful analysis of how basic accessorial liability has ended up. And it's because of the Chan principle. That has had a gravitational effect, if you like, on the principle. One sees it quoted in terms, my lord, in Rook. We can see no reason why there shouldn't be a similar foresight-based approach so far as ordinary secondary parties are concerned. And so the short point is this: BAL has not developed in its own channel with independent thinking as foresight being the right sort of test. It has been heavily cross-fertilised by the Chan principle, and so with respect, the attempt to draw some sort of mutual support fails. A point made by Lord Toulson this morning, if I may, we respectfully agree that if the test were a form of intent, if we go back to Anderson and Morris in the way that Miss Gerry and her submissions advocated, and I respectfully adopt that analysis, if we do go back to pre-Chan, Anderson and Morris-based directions, there is no particular difficulty and would be no particular difficulty for the prosecution to prove intent. Take the spontaneous mob violence example, which perhaps creates some of the greatest difficulties. If two men go off armed with sawn-off shotguns, it's not so difficult for the prosecution, but spontaneous mob violence may be more difficult. But there, the jury's attention, no doubt, would be to be directed on, well, where was the defendant at the time of the killing? What was his behaviour? Was he shouting aggressively? Was he behaving in a way such that the actual principal could only have derived support or encouragement from him? Those are all matters. Was he carrying a weapon? How close to the scene of the relevant pieces of action in the incident was he? All of those are common or garden, meat and drink matters at a criminal trial, which the jury could be invited to consider in order to consider the question, did the secondary party, did the man holding the coat, if you like, actually intend the killing to take place? We respectfully adopt Lord Toulson's observation that it wouldn't be an insuperable difficulty for the prosecution to prove intent, and in many cases wouldn't be difficult at all, any more than proving foresight is. Coming to the issue, and I've got two more points, my lord, coming to the issue of whether there is any concern about this issue in Jamaica, we will also specifically look. But with respect to Mr. Stevens, this really is a make-weight point. There is plenty of debate across the common law world about it. You have in the materials Australia, then we go to East London and Professors Wilson and Ormerod at Queen Mary. We stop at the University of Surrey for Professor Baker, who helpfully submitted a document to your lordships and to us, and then up to Cambridge and via Reading, Dr. Krebs and Dr. Baker. So there's plenty of concern across the common law world. But the short point is this: Jamaica is a common law jurisdiction. If the Chan error, as I'm calling it, is corrected, then it's open to Jamaica to reintroduce it via legislation. And there are lots of precedents for that happening. Your lordships, in 1997, in a case called Moses, held that the felony murder rule had been abolished in Trinidad. My Lord Hughes will well remember Miguel from a year or two back, where you looked at the death penalty for felony murder. The following year after Moses, Trinidad, by statute, reenacted the felony murder rule because Parliament in Trinidad felt that that was appropriate for Trinidadian conditions. And a direct parallel, if Chan is corrected and the Jamaican legislature thinks that for Jamaican conditions they ought to have, as other jurisdictions have, a formulation of the rule, then they can do it. It really isn't a valid argument when one is talking about development of the common law world. Well, will common law country X like it if we do it? The law would never develop if your lordships had those concerns. You are on a search with respect for principle, and in my respectful submission, there is no principled basis for the Chan rule. The outcome, my lord, and this is the last point.
Yes.
What should be the disposal in Ruddock's case? If you are persuaded that Chan was an error and that the law needs to be returned to its prior state, then we say it must follow that the case was left to the jury in Mr. Ruddock's case on a wrong basis, because they were told that foresight was enough, and if you decide foresight's not enough, then that was a wrong legal basis, and we would submit his conviction cannot be regarded as safe. We would, in that event, therefore, invite your lordships to quash his conviction. As a matter of strict theory, his conviction for murder, I should say.
Understand.
So far as alternatives are concerned, it would certainly be open to your lordships to consider manslaughter, but we say in reality it's difficult to see that there's room for manslaughter here, given the paucity of the evidence as to what he foresaw the knife might be used for. It's not a case readily that admits of the possibility he foresaw the use of a knife just to slash an arm or commit some form of injury stopping short of grievous bodily harm. So I have to accept as a theoretical possibility you would have to consider manslaughter in the terms of whatever principles you enunciate. But I certainly cannot readily foresee that manslaughter would be available. But if you require written submissions, of course, we will be happy to supply them.
Thank you.
On the question of retrial, unless your lordships determine on some reformulated basis, unless you determine there can be no coherent case of murder against Mr. Ruddock on whatever new principles you establish, then I don't detract from or I don't disagree with the proposition that the Court of Appeal will have to decide whether to order a retrial. My Lords, those are my submissions. Can I assist with anything further?
Thank you very much indeed.
Thank you. Oh, sorry, can I just say, we also have I promised the written directions I gave on yesterday. I've got a document, but I'll distribute that by the registrar, if I may.
Thank you.
My Lord, I'm sorry, but I forgot to mention what to do about Mr. Jogee going forward. Can I simply say this, that if you make a decision on the facts in his favour, we'd ask to know perhaps as soon as possible, because he is in custody. So if you're with us on the not guilty, and otherwise we'll make some written submissions in the same way that Mr. Knowles suggests. Thank you.
Anything you want to say about that, Mr. McGuinness?
Well, no, we discussed it, and we agree that depending on the outcome, if we could see what the judgments say, and then we can make written submissions.
I understand. Thank you. Well, we're very grateful to all counsel who've addressed us for their submissions, getting a lot of material in this on these important issues before us in time. We're also grateful to everyone who was involved in preparing the written cases and the other documents we've been provided with. Thank you very much. On the Jogee appeal, on Mr. Jogee's appeal, we will consider our decision and let you know in due course. In relation to Mr. Ruddock's appeal, we take the same course, but I should express myself in the time-honoured basis that the board will take time to consider what advice they will humbly tender to Her Majesty. Thank you all very much indeed. The court is now adjourned.